Matt Luka.
And spell it for us.
Luka.
All right, so tell us more about this letter. I know that it's going to be presented for the judge. Can you tell us more about the burn after reading notice letter?
So I can't talk about the specifics about the letter. Obviously, everybody is aware that it exists. It was in the possession of the FBI. And so now the motion we have before the court is a motion for protective order, where we're asking the judge to preclude its disclosure during discovery.
Why do you think that's important for your client? I mean, what's the issue here with it?
Well, really, we would just prefer that the letter not be shared with anybody. We would expect that if the letter is produced in discovery, that it will become public, and some of the words that are in the letter could be construed certain ways, and we would just prefer that it not be disclosed at all.
But this was something written before all this happened, and this is not, in your opinion, germane to any of the terrible, of course, events that have happened.
Yes. Our position is that the letter was written before Brian and Gabby even took their trip, and it really has no relevance to the cause of action that the plaintiffs have brought.
How is your client doing?
They're doing fine. This has obviously been a very difficult road for them, but they're hanging in there.
When it comes to the length of time, I mean, we're looking at a year now until this case. I mean, just explain why you asked the judge for this, particular, time to be taken to go step by step.
Yeah, so, one significant issue that we've had in this case is we really have not been able to take a lot of discovery, meaning depositions of the witnesses, even uncovering who the witnesses might be beyond our own clients. And part of that is that Mr. Riley made a FOIA request. A FOIA request is a Freedom of Information Act request to the federal government to provide them with the information that they gathered during the investigation, the criminal investigation of Brian. And so without that information, it's very difficult for Mr. Riley and really for any of us to know what the full scope of information available is.
Just to go back to the issue of the letter, has it been settled that the letter was written before Gabby and Brian set out on their trip? Has that part been settled? Because the letter is not dated, and the reason that Mr. Riley wants it is because that is in question. When was it actually written, and has that been settled?
Yeah, so by settled, there definitely hasn't been a judicial determination as to when the letter was created, but our position is that it was created before. Roberta Laundrie authored the letter, and so she knows when she wrote it, and she's filed an affidavit to that effect. So our position is that that's when it was written. We don't believe that there's any information that would suggest that it was written at any other time.
When you read the letter, it's emotional. It obviously portrays a difficult time in their relationship.
Yes, between Brian and his mom, and I'll just leave it at that. You can see that that Brian's mom cared very much for him, and that repairing their relationship was important to her.
Are you worried that the burn after reading part has become a distraction for this whole thing, and that people have ascribed a salacious sort of connotation?
I think that's the case. Yes.
Do you think that at this trial we're going to hear more about the alleged camping trip that they took when he was on the run?
That's hard to say. Our position is that camping trip really has nothing to do with the cause of action that the plaintiffs have brought. However, I'm sure that issue will come up during their depositions. They'll be asked about it. Whether or not it will be a feature of the trial, that I don't know.
Who do you expect to be as an expert witness, if any, for this particular type of trial?
That's really hard to say. At this point, I don't know whether Mr. Riley and the plaintiffs are going to call any experts, and certainly if they did, we would likely call an expert who may have a different opinion than that. Other than that, again, without the FOIA request and kind of knowing all of the issues that there might be, without taking the depositions of the fact witnesses and trying to understand why they did or didn't do certain things, it's hard to sort of say what expert may or may not be necessary.
The FOIA request is just to the FBI for their process and how they uncover this investigation.
My understanding is that it is to the FBI, although there may be other law enforcement agencies who are included in it. But yes, it is basically for all of the information that was gathered during the course of the investigation. So that could mean any sort of physical, tangible evidence that was gathered. It could be law enforcement reports, interviews of witnesses, things like that.
I'm not asking you to disclose these particular contents, but do you have any idea what the evidence is as to why the Petito family is so convinced that the Laundrie family was aware of what happened?
You know, at this point, I don't know because, you know, my clients have never seen that investigative file. I assume the Petito family has never seen the investigative file. So I don't know that anybody really knows exactly what the evidence is, if there is any at all. I'm sure they have their theories about what might be in there. I'm sure they were in contact with law enforcement quite a bit during the course of the investigation. So, you know, they may have learned certain things through that. So, but, you know, standing here today, I don't personally know what is or is not in there or what they feel like they have to have in order to pursue this case.
Thanks.